series, Let's Talk About Death. I was planning on speaking for about an hour. However, if anyone has questions, I thought you could use the chat box, or apparently you can unmute your sound and speak up. If we're running short on time or we're getting close to the end of the hour, I might ask you to wait until the end to see if we have any time, and I'll certainly be glad to answer anybody's questions offline. My contact information will be at the very end of the presentation. Okay, so the first thing I wanted to do is acknowledge the elephant in the room. It's certainly never a good time to talk about death. I think especially these days when we're confronted daily with mind-numbing statistics about COVID-19. Death is on the top of everybody's mind just about every day, but people react differently to it. Some people may have thought more about their own demise due to the virus, and others may think, well, gee, that's happening to other people. I don't have to think about it because it's not happening to me. And I just want to acknowledge it's a very personal subject, as I'm sure you'll hear throughout the series. So tonight I want to talk about death in the context of estate planning. And I want to hopefully give you a different way to think about estate planning that's not specifically or solely focused on death. And I also want to persuade you to do some estate planning if you have not done any so far. In particular, I want to start off talking about identifying the things that you value and the people you value, talking to your family and friends about it, and then writing it down. So we're going to spend just a couple minutes doing that. Before that happens, I wanted to give you just a little disclaimer. So take a second to read that. So I'm providing information tonight and not legal advice, but I would be glad to talk to you separately if you want legal advice. Okay, so what do you value? Do you have peace of mind about your future? You may have complete clarity, or you may have no clarity, and if you don't, that's okay. I think that's natural. But even if you don't, it's important to be thoughtful and clear-headed about decisions that could happen or you might have to make if you get sick or you're faced with a health crisis, or even, worse. You're looking at maybe a terminal illness. So do you have clear instructions for the kind of medical treatment you would want if you're sick and you can't communicate? Do your loved ones know how you would handle, let me start over. Do your loved ones know how you would want your possessions handled while they're grieving your absence? I don't think it's a coincidence that a lot of families experience discord after a loved one dies. I think a lot of it is because as a culture, we don't talk about death. It's not really the focus of a lot of discussion, even within families. And so a loved one who's passed away may have never expressed their values and what's important to them. And as those of us who are left behind know, it's not always evident what that person may have wanted if they didn't write it down or talk to their friends and family about it. So just to give you an analogy, a way of thinking about it, I used to work on a lot of contracts, and people would call and say, well, I had a verbal contract with Joe down the street, and now I want to sue him. If an agreement isn't written down, it's much harder to figure out what exactly was agreed to. Was there a breach, and who might be at fault? It's not impossible, but it's much more difficult and it's more complicated. And I think the same concept applies to estate planning. I just want to share a story about somebody that really didn't think about how things would transpire towards the end of his life. And this is a story that might resonate with some of you. This is a true story about a dad who was a widower, and he left, he let his daughter and her husband move in to the family home to care for him as he was aging. The daughter and husband ended up putting dad into a nursing home. Dad then died, and the daughter claimed that dad gave the house to her and her husband in exchange for their caregiving. Dad didn't say anything to the other kids in the family. He never wrote anything down. The daughter then became estranged from her siblings, and then lo and behold, the siblings filed a lawsuit against the daughter and the husband. So that's just one example of how the lack of communication and writing things down can cause problems. And of course, every family has a different dynamic. There's no question about it. I'm familiar with another case where mom and dad left their 5 children their vacation home in Ireland and specifically wrote in their trust, "We don't want you to sell this house for at least 30 years. The reason being is we want you kids to enjoy the house, share time together, and let your kids get to know their cousins." And lo and behold, in that case, the kids recognized what their parents wanted and they followed their wishes, and they're a pretty close family. So the point is, planning in advance of an illness or a death can minimize or maybe even avoid problems and complications later. So what is estate planning? I think of it not so much as death planning, but really a combination of life planning and death planning. So you can see here on this screen, I've listed some things about planning, directing your personal care and medical treatment, making sure you have sufficient resources as you age, appointing a guardian for your minor children if you have minor children, protecting your life savings, and importantly, avoiding the court probate process, which I'll talk a lot more about later. Why should you care about estate planning? Well, it's an opportunity for you to decide your health care in case you get sick and you can't speak, where you want to live if you need assistance, your medical treatment near the end of your life, and then who gets your stuff when you die. Instead of people that may not know you or your wishes, you're in control, essentially, and you can, in a very difficult situation, have some control when you're clear-headed and not up against a crisis where you feel like you have to make tough decisions. So there's a lot of things that get in the way of people doing estate planning. I've listed some common ones. I think some people think, I'm not wealthy enough, I don't have enough to bother. But if you have any assets whatsoever, then you have an estate. You may not have a home, but you may have family heirlooms, you may have a vehicle. So that's a common reason I hear people say they're not going to do estate planning. They might feel like they're not old enough, or it's too expensive, or it's too confusing, they don't get the lingo. Hopefully after tonight's presentation, you'll feel a little bit differently about some of these barriers. I thought for a second I'd get real and show you these death rates by age ranges. And as you can see on the left-hand side, it goes by decade. And so when you get to the 60 to 70 age range, you might think, well, gee, that's not too bad. You can see that men have a higher rate of death than women. It's about 5 to 6%. But then when you go to the 70 to 80 age range, it more than doubles. And so this is just a realistic stats on lifespan. And it's hard to think about death, but if it helps anybody to see these numbers and it spurs them to take some action, well, I think it's worth it. Of course, that's not the whole story, because as the chart shows, I'll just back up for a second, you can see consistently that men have a higher death rate than women. So I just wanted to spend a minute saying that nowadays women are divorced or not married. And if they are married, they're 4 times more likely to be widowed, and they're living longer in their widowhood. And so to me, that means if you're a woman, you probably need estate planning more than a man, because statistically you're going to live longer. But the other aspect is it's not just death rates. This slide is entitled, Let's Talk About Disability and Incapacity. This doesn't necessarily factor into those death rates. We know accidents and horrible diseases, dementia, viruses, those things can strike people at any age. And so estate planning really shouldn't be limited to people in their 50s, 60s, and 70s. It really can come into play much sooner, with the thought that something could happen to you where you're not able to work, and you might even need to live in a place outside your home so people can care for you. And so this slide is really just to point out the obvious, that it's going to rain on everybody's parade at some point. And accepting that, I think, helps move you forward, at least in terms of estate planning. And so what I'd like to talk about now are the core estate planning documents. During life, we have the Advanced Healthcare Directive, which is also a healthcare power of attorney, and then the Durable Power of Attorney for finances and legal. Post-death is the will, and then the Revocable Living Trust is both during life and post-death. It's a really flexible estate planning tool, and it's extremely common nowadays, and I'll explain why. So the powers of attorney generally, so here I'm talking about the healthcare power of attorney or advanced directives, and the durable power of attorney for finances and legal. You have some common themes and terms. So if you see a reference to the principal, well, that's you, the person that has capacity, and you're granting another person legal authority to act on your behalf. And that authority can be narrowly tailored or it can be very broad. The agent is the person who's acting on your behalf. And then there's this notion of capacity. And so anybody who's a principal has to possess sufficient mind to understand, I'm just going to move that, in a reasonable manner, the nature and effect of their actions and decisions. And of course, this is contextual. It's a facts and circumstances situation. And we know capacity can vary. It can vary by day or even within a day. And somebody's functional impairment doesn't necessarily mean there's a legal incapacity. So there are two different things. Just keep that in mind. And so when you're thinking about, if you're the principal, well, who should be my agent? Then you really want to think very carefully about somebody who's trustworthy, who knows your wishes and values, who's organized. Do you want one agent or two agents? And then the big takeaway is, by appointing an agent who can act on your behalf, you can avoid having to go to court and have a guardianship case. And those are very public and expensive and time consuming. So this is a really great tool to avoid having to go to court. So the Advanced Healthcare Directive, or as I said, the Durable Power of Attorney for Healthcare, lets you appoint an agent to make decisions for you. It's that substituted judgment. It can be effective immediately or springing. And the springing part is that you could have conditions that must be satisfied before somebody could be your agent. A common one is where a doctor or two doctors, generally two doctors, would deem you to be incapacitated. And then, and only then, would they have the authority to act on your behalf. And they can make, your agent can make all kinds of decisions as you specify in the power of attorney, whether it's choosing a healthcare provider, determining what type of medical tests or treatment you're going to get, and also whether you're to be able to stay at home or you need assisted living. So you get to tailor that power of attorney for your healthcare. And this, I think, is a must-have for anybody over 18. Even kids as young as 18, 19, they're in college. This is a very common thing because once you're over 18, nobody can really speak for you unless you have this power of attorney. And of course, as we said, a guardian, but that's not a preferable option to have a guardian. Okay. I'm just moving my screen here. I just wanted to mention living wills. This might be a little confusing for some folks. A living will is not a will per se. It can be part of an advanced healthcare directive, or it can be a separate document. And this is really tailored to end of life type decisions. So if somebody has a terminal illness, what kind of care do they want? And in this situation, usually the person, they could be, they're not conscious, they can't speak, but the agent can make decisions for them, including something like comfort measures only. And so the next thing I wanted to show you is a video. It's actually from a group called it was I guess started by a group called the Conversation Project. I don't know if any of you have heard of it, but ABC did a story on a particular family that followed the guidelines of the Conversation Project. So I hope the video works. So we'll give it a shot here. I think you'll find it very interesting, and it's actually from 2014, so it's a little dated, but I think it still has a great message.
And finally tonight, ABC News wants to join you in something right at the heart of the American family. How about all of the people who care about us make decisions near the end of our lives? 9 out of 10 of you told us that we should all do something about it and already do what we want.
Nancy, it kind of cut out, so we can't really hear it anymore.
Oh.
You want me to try?
Yeah, that would be great, Leah. Thank you.
Let me see. Hold on a sec. Can you see my screen? Can you see my screen, Nancy?
No, I don't. I don't see it.
Let's see. It says my screen is being shared. Okay, let's see. Here, I'll start playing it.
Right at the heart of the
Okay.
Could you see it?
I can hear it.
family. We can all help the people who care about us make decisions near the end of our lives. And 9 out of 10 of you have told us that we should all be talking.
Sorry, could you see it or no?
No, I don't see it.
Okay, let me try it again. Now can you see it?
No.
Huh.
I could try to play it with the subtitles. It's not as good, but
Or could you pull it up from YouTube and share it out of your PowerPoint? I don't know why it's not. It's saying I'm sharing the screen, but it's not. I don't know why Zoom is.
can other people see it, or?
I'm kind of thinking if you can't see it, then.
Yeah, I mean, I see my screen.
But you don't see my screen?
No.
Let's see. Okay. I will stop sharing.
Well, maybe I should just get out of mine and do stop share.
Okay, you stop sharing and then I'll try to share mine.
Okay.
Okay. Can you see it?
Yes.
Okay, awesome. Okay.
About it at all ages, what we want, and yet only a fraction of us have done it. And we know it makes a huge difference in the health of the caregiver as well as those cared for. So ABC News has taken cameras inside a vital, loving family, part of a new community, deciding to have a conversation. This is 85-year-old Norm and his daughter Maureen.
My dad is 85 today. He's still very, very active. He's a wonderful friend.
Throughout life, daughter and father have always talked about everything, except one thing: how to control the end of your life in the same way you control the prime of your life. So dad and daughter gather the family together, 3 generations, for an act of love.
And so now we're just asking that you share some of your thoughts about what you would like at the end of your life, so that we can honor your wishes.
They are part of something new underway for families in America that says having the conversation is a gift parents and children give each other. And there's proof of the difference it makes. Studies show depression rates plummet after a loss if the families have had the conversation. Renowned physician Dr. Atul Gawande says doctors and nurses see it firsthand.
When you're there in that moment and you're talking to the family and you're saying, how much will it bother your father if he ends up this way? And they say, more often than not, I don't know. We never talked about it. That it is incredibly traumatic for the family, for the doctors involved. There's often conflict. It can tear families apart.
So Dr. Gawande has become part of a team led by Pulitzer Prize-winning writer Ellen Goodman. It is called the Conversation Project. It is a kind of guide for families looking for a way to begin.
If we give them a way to talk about it and give people something to hang on to when they're afraid to start this conversation, they can do it and pass it on.
Families like the Jennings. They looked over the conversation guide before they sat down together. First, there's laughter.
Oh, my golf swing's still good.
And then Dad directly eases his daughter's guilt and worry about having put their mother in hospice.
I felt like that meant we were giving up on Mom.
She was in a lot of pain, and I think it was handled real well.
And next, Maureen asks her dad for clarity on what he considers a good end to a great
Okay,
life.
So if you were in a condition where you couldn't make decisions for yourself, how extreme would you want us to take measures to save your life versus letting you go?
Well, I think I'm ready to go anytime. You know, I wouldn't prolong anything. I mean, I've lived a great life. Pretty lucky. And because of you guys, you know.
Unexpectedly, a grandson is inspired to speak up about his own wishes for his own life.
That if there was no meaningful communication, that I would want you to stop trying to intervene.
We aren't ready for you to go that soon.
Well, we're not ready for you to go that soon either, so.
One by one, the others weigh in, all ages.
Happy birthday!
And with that, another family has joined a kind of estate planning for the heart.
Go!
A conversation beginning in America. So please tell us your stories in the days ahead about ways to begin the conversation with family members of all ages. Or if you don't want to have it, tell us about that too. My colleague and my friend, anchor Bill Ritter from WABC, and I will be reading your emails and looking at the great photos you're already sending us of your families. So go to abcnews.com, find the conversation and the guide, and we'll be seeing you right there. And finally tonight, ABC News wants to join you in something right at the heart of the American family. How we can all help the people who care about us make decisions near the end of our lives. And 9 out of 10 of you have told us.
You're up.
Okay, can you see my screen?
No.
No, okay. Let me try this. Can you see my screen now?
No.
No. Okay.
Yeah, what did you do
Oh.
last time?
I don't know.
Go.
Well, let's see. I'm sharing it.
Okay. You did it before. Okay.
Well,
Do you want me to go and find?
yeah, that would be great. Thank you, Leah.
Okay, 1 second. Sorry. Let's see.
You want me to try again?
I'll try it again. It's loading. Sorry, I should have had it ready to go. Oh, it's
Okay.
worked.
Okay. Okay, great. All right, now I'm going to go back to my slides here. So I will say I am sorry if that was hard to hear, or anybody who has any questions on it or wants the link. I would be glad to send it. I think it's really great, even though it's dated. I just love the message in it, and I hope you do too. And so just wrapping up on advanced directives and the healthcare power of attorney, some related documents, there's what's called a HIPAA release, and this gives your agent access to your medical records and the ability to talk with your healthcare providers. It can be standalone or it can be separate. Some people like it separate because then they can just give it to the healthcare provider. There's also do not resuscitate orders, or DNRs. You've probably heard of those. And the YO Pulsed is a 2-page form that you review with your physician, and you make your wishes known to your physician, and then the physician would put it in the medical records of his or her office. And so that's a good thing to have in your records. Okay, I was going to go on to the power of attorney for financial and legal matters. I did see, I think there were some questions or comments in the chat box. I'm a little afraid to click it. Leah, are you able to see the chat box?
Yeah, there's no questions so far. There were just questions about the video, and I posted a link to the video if anybody wanted to click that later.
Okay, great, great. Okay, so I'll just keep on moving here. And now talk about the power of attorney for financial and legal matters. It's a little bit of a leap of faith anytime you're the principal and you're appointing an agent. So this power of attorney is more for finances and legal. Similar to the advanced directive, it can be immediate or springing. You get to define the scope of the agent's authority, whether it's broad or narrow. One thing that's unique about this power of attorney is gifting. And gifting is used sometimes when a person's trying to qualify for Medicaid. And so you have to have very low income and assets in order to qualify for Medicaid. So a common strategy is gifting your assets. This is a whole complicated topic that I won't go into much more, but essentially for government benefits, gifting is a very popular tool. And then similar to the advance directive, avoiding having to go to court to appoint a conservator if you don't have a durable power of attorney for finances and legal. So I just wanted to put up another slide about agents, because one thing I find is when people come to my office, they're really not sure who their agent should be, and it's very critical that you pick somebody who's trustworthy, but also has the wherewithal to carry out your wishes. So for a durable power of attorney for finances, you would want somebody that's good with finances, or at least knows that they need help and they will seek professional help. They should be organized. They're taking on a particularly high legal duty. It's called a fiduciary duty. So that means that agent has to act in your sole best interest and not their own. Again, you could have one or two agents, and it's a great tool to have, or a great document to have, so you don't need a conservator in court if it ever got to that point. And so I can't stress enough how important it is to choose an agent that you really trust and somebody who knows you, if you can do that. And then I just wanted to spend a few seconds here on elder exploitation via the durable power of attorney. Durable powers of attorney have been known by some people as a license to steal, unfortunately. There is a lot of undue influence when it comes to elders, and it's extremely prevalent. It's difficult to investigate. Accountability is sometimes not built into the power of attorney, so nobody's seeing what could be going on with mom or dad's bank account. And unfortunately, the statistics show that often it's a family member that is taking advantage of mom or dad and using their money in ways that they shouldn't be. And so everybody is considered a mandated reporter when it comes to elder abuse and exploitation. So I just wanted to mention that as great as these documents can be, they can also be dangerous if they're in the wrong hands. Okay, so now we're just going to move on to wills. I'm thinking most of you probably know what a will is, but just to recap, it's your ability to appoint a representative, a personal representative, to basically wrap up your affairs. You get to make specific gifts to specific people or charities. You make direct payments of your debt and expenses. You get to direct that. You distribute your estate, and you also get to appoint a guardian if you have minor children. Wills are a great tool as well, but they don't do everything. You still have to pay taxes. You don't get out of paying your debt. So you probably knew all that, but for anybody that didn't, I wanted to just point that out. They also have very strict requirements. They're creatures of statute. So they have to be written and signed and dated by the person making the will. They have to be witnessed by at least 2 people over the age of 18 who are not beneficiaries, and they have to be notarized. These are the most common kind of wills we have here in Wyoming, but you can also have a holographic will, which is a will that's completely in the maker's own handwriting. Those do not have to be witnessed or notarized, but they're not as good as following the statutory requirements of a written will. And so what happens if you don't have a will? Well, in Wyoming, just like every other state, we have intestacy laws where the state has a scheme that if somebody doesn't have a will, then the state statutes will decide who gets your stuff. So in Wyoming, generally it's half to the spouse and half to the kids. And that could be a problem when you have blended families or it's not what you would have otherwise chosen. Some people don't want to give things to their family members and they actually would like to disinherit them. But if you don't have a will, that's not going to happen. Chances are your family members are going to get your stuff. And so the other thing about a will that most people don't know is that you have a probate estate, even if you have a will. So probate estate rather is all your assets and debts, except for property in a trust, property owned jointly with another person, property that's subject to beneficiary designations, and lifetime gifts. So that does exclude quite a bit. But for everything else, it goes into your probate estate, and you have a probate estate whether you have a will or not. And so one of the things people commonly do to avoid this probate process is they have a trust. And so here I just noted a few things about the probate process. It's judge supervised. There are a lot of administrative rules. There's no privacy. It's completely public for the most part. It can be expensive, 1 to 10% of your assets. It's also very time consuming. And if you have an estate that's under 200,000 in Wyoming, you can use the summary probate, which is basically filing paperwork. You may not need to go through all the administrative hoops, but it still can be time consuming. And so that's why I have this fellow here saying, is there a way I can avoid it? And so as I've already hinted, one way people do that is through a trust. Trusts are separate legal entities that hold your assets. And there's usually a trustee that holds and manages those assets. And it can be both during your life and after you die. So they're very flexible. The other really great thing about a trust is you can avoid the probate process. If all your assets are in that trust, then it is not subject to probate. And of course, that doesn't include the things I said that were initially excluded from probate anyway. And so for anything that isn't excluded from probate, if it falls in a trust, then you don't have a probate estate and you don't have to deal with that. Trusts are extremely complex. They can be simple or they can be complex. There's all different kinds of trusts. The most common one that I see is the revocable living trust. And just by way of terminology, you have a settlor, that would be you, the trust maker, a trustee, that can also be you, and you can also be the beneficiary. So a lot of times it's if you think of it as a will substitute, it can be a really effective tool. And people use them for shielding assets, to minimize taxes. So that's when it gets a lot more complex, but they're great tools and can handle a lot of different variations in terms of what you value and what you want to do with your assets. One thing to know about trusts, especially revocable living trusts, is they need to be funded before you die. Some states require funding immediately, but here in Wyoming, as long as you fund it before death, that's fine. So basically it means you need to retitle the asset in the name of the trust or the trustee. And this would include things like real estate deeds and financial accounts. I can't stress to you enough how important it is to fund a trust. I had an experience in my own family where my mom set up a trust shortly after my dad died, not knowing that she needed to transfer the deed to the family home to the trust. That didn't happen. And so luckily we figured it out before she passed, but that could have been a disaster. I mean, I'm exaggerating a little, but it would have meant going through probate, and we really did not want to do that. So trust versus wills, as I said, they're more complex. They can be expensive to set up initially. They have to be properly funded and timely funded. And there is a tax on trust income that's higher than the personal tax rate. So that's just the very high level discussion about trusts, but they're very common in estate planning. So there are some other really important documents that can stand with your trust or will or stand alone. For example, you can list your tangible possessions in a separate document, such as family heirlooms, art, photos, jewelry, and that can be amended without having to go through all the formalities of amending a will. And some people find that very helpful. Same with funeral and burial wishes. So they can be attached or they can be separate. I like to attach them because I think it's easier for people to keep all those important documents together. Kind of makes sense that you would do that. And then there are some other documents that people like to have in addition to their other estate planning documents. If you are, for example, going to leave more to child 1 than child 2, you might want to explain why to avoid discord later on. Some people like to leave letters to their children or grandchildren, sort of saying, here are some mistakes I made, and you don't have to make the same mistakes. Really practical things like a list of accounts and passwords, the location of important documents. And I think this one is interesting because you or somebody may not want to share every detail about their estate planning document, but at least let people know where those documents are located. I get, no exaggeration, probably 5 emails a week from attorneys in Wyoming who are reaching out to say, have you seen Joe's will? Have you seen Mary's will? Because apparently these people did wills, but nobody knows where they are. So that's pretty important. A list of beneficiaries with contact information, and then finally care instructions for beloved pets. And so what I really wanted to emphasize tonight was that estate planning is more than just the documents. The documents are important, and as we've discussed, they do have some legal formalities, but I think underlying all of those legal formalities and documentation, that just the mere documentation, is some other things that you might want to accomplish with your estate plan, whether it's preserving and sharing memories, passing on wisdom and keepsakes, settling relationships, making peace with God or your higher power, ensuring those left behind will be okay, and then establishing your legacy. So there's definitely a legal component, but I think there's a huge emotional component and spiritual component as well. And so what do you value? I'll leave you with a few final thoughts. The best time to plan is now. Whatever you write can be changed. If you get started, especially with your advanced healthcare directive and your power of attorney, I think that would be an excellent start, because that involves your life and what could potentially be a really tough situation, you get to call the shots. Planning is going to help you get organized. Talk to your family and friends, address the conflicts that might arise. Check out the conversation project, whether it's that video or go onto their website and see what resources they have to help you get that conversation started. Think about who will be a good agent, who will be a good personal representative, who would be a good trustee. These have to be people you trust implicitly. Review your plan and update it as needed. And then finally, make copies, store it in a safe place, and let somebody know where you store those important documents. And I just wanted to share with you some of the resources I used, the conversation project, the video clip that we got hopefully to work okay. And then I really like this book called Get Your Ducks in a Row, Baby Boomer's Guide to Estate Planning. It's by Harry Margolis. He's an estate planning attorney, and he writes a very cogent, entertaining book on this subject. So if you can, check it out. And I just want to thank you for your time. And please let me know if you have any questions. Here's my contact information. And Leah, I can't see the chat box, but if anybody has any questions, I think we have some time to answer them.
So there's a couple questions in the chat. First of all, I want to ask though, so say somebody wants to do a will versus a trust, they've decided which one they want to do. How then do they go about doing it? Do they have to go see a lawyer? Do they go online? What is that process to actually get it done?
I think that's a great question. And there's been a proliferation of do-it-yourself wills and trusts. You can go online and very easily find companies that will help you and even draft those documents for you. But big warning is that they don't know Wyoming law, and they don't generally sit down with you for an hour or two or more and help you figure out what's important to you and how to draft it. So I would say, and I might be a little biased, going to see a lawyer, even for a consultation, and then figuring out what direction you want to take, whether it's a will or a trust. I think trust planning is very common, and people have both, but they will make the trust their primary estate planning document with the will sort of as a backup if needed. So yeah, I would say going to talk to an attorney is really your best bet. But some people don't feel like they need that, and they'll hire an online company to do it, which for some people is just fine. For other people, it isn't.
Okay.
Did that answer your question?
Yeah.
Okay.
This one is from Kathy. Can you provide a list of things that can go into a revocable trust and things that cannot?
Well, usually you indicate what is in the trust. I guess the question was, are there certain things that cannot go into a trust? Off the top of my head, I can't think of anything. I think the key is whatever is in the trust has to be titled to the trust. You don't necessarily have to put like your personal possessions, like possession by possession, and then retitle it. You don't have to do that, but anything that has a title or deed has to be in the name of the trust or given to the trustee of the trust. So you have to be clear on how you're naming those assets if you want them to be included in the trust. But the only thing I can think of now that I'm thinking about it a little more is you have to be careful with guns. There are gun trusts, and that gets a little bit beyond my scope if anybody's interested in that topic. And I'm not talking about like family heirloom type of guns. I'm referring more to guns that have to be registered with the federal government. Those have special requirements. So that's the only thing I can think of.
Let's see, there's some elder care. Are there any resources for identifying elder abuse articles or videos?
There is a lot of stuff. And if you would like, Leah, I could share that with you, and then
Okay. And we can put it on the website.
or we could put it on the website. But yes, absolutely. That is a really, really hot topic.
Okay.
And it's really sad topic too. I know Florida is one state that has really improved their laws to deal with that because there's so many elders that live there. I don't think we have the same thing in Wyoming, but we probably should. So I'll make a note to send you some information on that.
And this is from James. I have one elderly parent who stated it was all set up with beneficiaries. Does this option create challenges? So I guess maybe the question is like, say my investment account, I have beneficiaries. Do then I need a will as well or a trust?
You may not. You may not. A beneficiary designation is pretty straightforward because whatever is distributed from the account goes directly to the beneficiary. Where it gets a little tricky is if you have a beneficiary that may not be good with their money. They maybe have, gambling problems or other substance abuse type issues. So if it's a lot of money, you may not want to just give them a lump sum directly without any parameters on that.
I think that's the last question. There was a question, would you be willing to share your PowerPoint slides and put that on the website for later?
Sure, absolutely.
Does anyone on the Zoom call, would you like to ask a question directly to Nancy? You can just unmute yourself, ask it, or do the little raised hand thing. Just one new question. Otherwise, there's one more question in the chat. I'll just wait a couple seconds if anybody wants to unmute themselves. Okay, so this one is from Morgan. Is there a specific state statute Wyoming residents should familiarize themselves with regarding estates?
There are a lot. We have statutes on wills. We have a uniform probate code. We have a uniform trust code. And so similarly to with the links on the elder care and my PowerPoint, I'd be glad to put up some links to the Wyoming statutes that people can look at if that would be helpful.
And then this one is a follow-up to the revocable trust question. Are income producing assets, i.e. stocks, put in a trust?
Yes, they can absolutely be put in a trust. Yep.
This one's from Alana. I'm in Idaho. Do you have referrals?
I can certainly get some.
Yeah, so email her again if you want that. I think those are all the questions in the chat. Anyone else have any other questions? Okay, so let me recap just to see if I understood correctly. So what the difference between a will and a trust is, a will is something that I can just create myself. I could do a handwritten thing, create it, tell somebody about it, have two witnesses, and I can list anything on there.
Well, maybe I went over that too quickly. So the holographic will is, I think it's sort of a holdover from the Frontier West times when it was hard for people to follow the specific, statutory requirements. So they were allowed to write out a will in their own handwriting and then sign it and date it. And that was good. As times evolved, though, the Wyoming legislature passed very specific statutes on will requirements. And so there are certain things you don't necessarily need to put in a will, and you probably shouldn't. Anything that has a beneficiary designation doesn't even go in the will. It can go directly to the beneficiary. People generally put things like their house or their car or their personal possessions. They indicate who's going to get them. They might put cash gifts in their will to not only people they know, but charities. And if the will meets the statutory requirements of being witnessed and notarized, then if everything's in good order, then that makes the probate process go a lot faster.
And then a trust is different from a will because you said it's more complex, and I have to sign over all of my assets to being the trustee of the trust.
Basically, that's right. Yeah.
And when you say it needs to be funded, they just literally have to be transferred to the trust. Not necessarily I have to keep putting money into it.
Right. You can set up a trust without anything. But before you die, you want to fund it. And so anything that has a title has to be retitled to the name of the trust. And so
If you fund it, you just mean retitle it.
Yeah, basically, yeah. And so the big benefit of a trust is that it doesn't go through the public probate process. And that's a huge reason why people like trusts, because it's private. And the structure of a trust is that you have a trustee who's sort of managing the assets for the benefit of the trust maker or the settlor of the trust. So it's really a separate legal entity.
Great. Cool. So we're just at 7 o'clock. Are there any last minute questions? Okay, so check back on our website, tclib.org, and if you go to the Let's Talk About Death series, we will post an updated list of resources that Nancy has mentioned. We'll put her PowerPoint slides there and all those types of things. And also, Nancy, if you share, sorry, I just unshared your screen so that we could see. And share your screen again. I don't know if Zoom will let us do that again. It's been finicky. Do that, and so we could see your contact info. Otherwise, wait, there's a couple more questions.
Okay.
If you inherit a 401k, do you have to keep it in its current form?
Oh, sorry. Can you say that again? I didn't hear it.
If you inherit a 401k, do you have to keep it in its current form?
It depends. If it's under $5,000.
You need to speak directly to your microphone.
Me?
Yeah.
Okay. Sorry. It depends. If it's over $5,000, you can usually keep it with the institution. If it's under that amount, sometimes they want you to cash it out. And you can also roll it to a different institution. So was the question about an inherited IRA or just,
yes.
an inherited 401k?
Yep.
Okay. Yeah. So inherited IRAs have different rules than 401ks, but generally what I said, if the 401k is over 5,000, you can keep it where it is, or you get to pick another financial institution and change the investments around too, usually. It depends on the plan, the retirement plan.
And then what is the tax rate on trusts?
Oh, that's a good question. I should know the answer to that, and I don't. But I can answer the person's question separately. I'd have to look it up.
And one last question from me. How much does setting up a trust cost?
I think it depends on how complex it is, and lawyers have their own rates. So they tend to be more expensive than, say, a will or a power of attorney, but they don't have to be expensive if they're pretty straightforward.
Like thousands of dollars or hundreds of
In
dollars?
some cases, lawyers can charge $3,000, $4,000 or more. It really does depend.
All right.
I don't charge that.
Okay. Yeah. So what is your email address again for them to?
So it's Nancy, Nancy, at Norton, Norton, law.com.
Great. All right. So thank you so much. And we will update the website with all the resources, and join us next week for the talk with Oliver Goss on hospice and grief counseling. And then in early December on how to write eulogy and obituary. And if you have any suggestions, please email me at adultevents@tclib.org.